everyone. Welcome to our very first HHQ webinar series. We are glad to have many esteemed attendees with us, with over 30 different organizations with us today. And my name is Calvin. I'm your MC today, and together with me is Miss Alicia Chua, and she will be hosting in Mandarin.
大家下午好，欢迎来到我们 HHQ 的网络研讨会系列。非常高兴多位能够参与我们通过 Zoom 的网络研讨会。
So the COVID-19 outbreak and implementation of the Movement Control Order, MCO, have greatly impacted many individuals and businesses in Malaysia. Just yesterday, our PM have announced a further extension of 2 weeks, which have created further worries, stress, and burden of many particular the business owners.
新冠肺炎的爆发和行动管制令的执行极大地影响了马来西亚人以及企业。就在昨天，首相已宣布行动管制令的2个星期延长，造成了许多特别是业主的担忧、压力和承担。
In view of this, we Halim Hong and Quet are organizing this webinar today to zoom into the effect and implication of MCO on 2 broad contentious areas, namely contractual issues and employment issues.
我们 Halim Hong and Quet 因此主办了今天的网络研讨会，来探讨行动管制令对于合约，特别在不可抗力方面所面对的问题和就业所面对的问题的影响和意义。
So our webinar today will be broken into 3 parts. Firstly, we will have Mr. Ankit to share with us on COVID-19 and its effect on contractual obligation. And secondly, we will have Mr. Tu to share with us on the topic of impact of movement control order on employment-related issues. And lastly, we will proceed with a Q&A session.
我们的网络研讨会将分成3个部分。第一，我们的 Mr. Ankit 即将分享新冠肺炎以及其合约义务的影响。第二 ，Mr. Du 将与我们分享行动管制令对职场相关问题的影响。随着最后是由我们的 Dato' Quet 主持的问答环节。
So before we dive into our discussion today, allow me to introduce a few housekeeping matters. First and foremost, the audio of each of our audience today will be muted to ensure maximum hearing of our speakers' presentations.
在此有些指示需大家注意，请注意我们会把观众的音响静音，以确保我们演讲者声响的最佳效果。
Even though you can't use your mic, but we welcome you to put forward your questions, if you have any, into the chat box as indicated in this slide on the right side of your screen. We will address this question at the Q&A session.
我们欢迎您的任何问题在此处所显示的聊天室提出，我们将随后回答问题。
Without further ado, allow me to introduce our very first speaker of the day, Mr. Ankit, who is our partner for Dispute Resolution Department of Halim Hong and Quet. He had represented a number of multinational and government-linked companies in Malaysia, both in advisory and lead counsel capacity at all levels of Malaysian courts. Mr. Ankit is also an accredited adjudicator and the Vice Chairman of the Membership Development Committee of Asian Institute of ADR. He will kickstart the webinar today by sharing with us on COVID-19 and its effect on contractual obligations.
先介绍我们第一位演讲者 Mr. Ankit， 一位在 HHQ 诉讼与Mr. Ankit 同时也是亚洲替代性纠纷解决协会认可的评审员和会员发展委员会的副主席。他即将呈现关于新冠肺炎以及其合约义务的影响。
Although we can't really hear you, but let's put our hands together and welcome our first speaker, Mr. Ankit.
有请 Mr. Ankit.
Thank you, Kelvin, and thank you, Alicia, for that nice introduction. And also a very warm welcome to all our guests and participants present here with us today. This afternoon, I will be sharing with all of you a few pointers on the effect that the COVID-19 outbreak has brought about on contractual obligations across the board. When we say contractual obligations, there are all sorts or all types of contracts that one can think of. It could be contracts for supply of goods, it could be contracts for performance of services, it could be a contract of employment, and many other variations of contracts. But in essence, COVID-19, of course, undeniably has brought out certain obligations to a halt. Certain things are not performable at this point. Parties are not able to carry out tasks that they would have to perform under certain contracts, and therefore the impact generally is said to be quite serious. The World Health Organization had recently, of course, declared the coronavirus or the COVID-19 outbreak as a public health emergency of international control. Now, the International Health Regulations 2005 has defined this public health emergency of international control as an extraordinary event which is determined to constitute a public health risk to other states through the international spread of disease and to potentially require a coordinated international response. So there we have it, the definition of the International Health Regulations or the definition of PHEIC under the International Health Regulations is indeed quite a serious issue. And we have seen that as a result of the WHO's announcement of it being declared as a world pandemic, many countries have implemented various protective measures and restrictions to properly manage the COVID-19 outbreak. In Malaysia, for example, a movement control order, or some of us call it the restricted control or restricted movement order, was introduced by the Malaysian government on the 16th of March. And the order is meant to be enforced from the 18th to the 14th of April 2020. We have seen this announcement made yesterday. What was initially a deadline of 31st March 2020 has now been extended for a further 14 days up till the 14th of April 2020. So we're looking at almost an entire month of works being suspended in many industries, unless of course you are under the essential services category, which is by far and few not many in comparison with the rest of the industries of the country. Now, with the implementation of the order, of course, we expect that many businesses may find that they or their counterparties will struggle to meet contractual obligations under their particular contracts, at least for a temporary period during which this order is enforced, which means at least until the 14th of April, if not longer. So to begin, I will first explain how COVID-19 could affect contractual obligations, just from a very general perspective. The limitations and restrictions that arise from the COVID-19 outbreak could enable a party that has entered into a contract in Malaysia to avoid its obligations. Now, when I mean avoid its obligations, it means you have two options. One is you can either invoke a force majeure clause, which is a particular clause which would be spelled out in your contract, or if you are unable to do so, the other option you would have is to rely on the statutory concept recognized by our Contracts Act 1950 of the concept of frustration of contract. So these are two general advices that we would usually give to our clients should there be any reason parties wish to avoid obligations or to suspend obligations or to even terminate a contract for that reason. This would be the two main avenues that we have at hand. It is, however, of course, important to note that both these methods have got different thresholds that apply, and understood parties would require professional legal advice before pursuing either one, because both of them have got very different requirements. And in this session, I will, of course, explain the different requirements under force majeure or frustration under the Contracts Act. Now, I will begin by explaining what is force majeure in terms of definition, at least. The term force majeure is taken from the Commercial Code of France and is used in reference to all circumstances independent of the will of man. and which is not in his power to control. So I think the key references here is independent of the will of man and which is not in his power to control. But it is important to note that this is just a wide definition, or the definition as provided under the Commercial Code of France. But in simpler terms, force majeure simply refers to the occurrence of events that are beyond the control of parties in a contract, such as natural disasters and war, to name a few, that prevent one of the parties in the contract from carrying out its contractual obligations. There are, of course, many other types of force majeure events. We will deal with that later. But force majeure clause in a contract will usually stipulate that the defaulting party should not be held liable if a listed force majeure event either prevents, hinders, or delays that party from completing the contracted work. So essentially, this is a saving clause for parties who are trying to suspend obligations under a particular contract, should the contract spell out expressly a particular event which has occurred and which is out of the person's control, and which is something that is hindering that person or that party from completing his or her obligations under the contract. So the next question that we would of course have is whether or not the force majeure clauses in your respective contracts in fact cover situations like COVID-19. Now, to understand this, I think it is very important for us to first appreciate the fact that force majeure in Malaysia does not have any independent meaning. And what I mean by that is that its principles are not automatically applied to commercial contracts. So while I had given a wide definition of force majeure just a moment ago, the meaning under Malaysian law is not defined specifically, and ultimately force majeure is applied as per how contracts determine the particular clause. So that is what I've mentioned in my second bullet point of that you'd see on your screen. It is the precise wordings of the clause in each individual contract that will ultimately determine what is or isn't covered. So to put simply, your contract is ultimately your be all and end all. What you have mentioned as your force majeure clause under the contract is ultimately what will be covered. Now, of course, due to the recentness of this outbreak, it is indeed very unlikely that any force majeure clauses in any contracts would explicitly list COVID-19 as one of the eventualities. I think for obvious reasons, because this is something that has never occurred before, all contracts would not specifically mention COVID-19. However, it is very possible that we have force majeure clauses around in contracts in Malaysia that specifically mention other terms such as epidemic, pandemic, government intervention, quarantine, or disease. These are just a few examples, but should your contract, of course, mention any of these events as a force majeure event, then a defaulting party who intends to suspend the contract temporarily would be able to rely on the force majeure clause, and of course, he would be able to do so if all the requirements are met. Now, as far as the requirements are concerned, I will come to that shortly. What I mean is that even though there is a pandemic that is currently occurring, but if it is not preventing you from providing those services, if it is not hindered you from providing such services, it will not, you will not be able to rely on the force majeure clause. Now, so as I mentioned earlier, the requirements that are normally expected of a party who wants to rely on a force majeure clause, the party must show the following things at the very least. And these are the 4 events or the 4 occurrences that must happen, or the checklist that must be ticked in order for you to be able to rely on a force majeure clause. Now, the first thing is, of course, the starting point of it all, which is that one of the events referred to in the force majeure clause has occurred, which means if the event is not occurred, if the event is not listed as a force majeure clause under the force majeure clause, then it will not be a force majeure event. Simply put, it must firstly be identified in your contracts. The second checkpoint is that if it has prevented, hindered, or delayed the defaulting party from performing the contract, this is, as I explained earlier, you just must be able to show that there is an absolute bar from enabling you to perform certain obligations under the contract. Thirdly, that its non-performance was due to circumstances outside of its control. And fourthly, that there were no reasonable steps that it could have taken to avoid or mitigate against the event. Now, in the situation that we are in, I would think that the movement control order definitely meets all of these criteria, because except for the first one, of course, the first criteria depends on what your contract states, but it without a doubt has prevented, hindered, or delayed many parties from performing certain obligations under the contract. And it is also without a doubt that the non-performance of these parties is outside of its control, and there were no reasonable steps that it could have taken to avoid or mitigate against the event, simply because there is a bar against people providing certain types of services unless you are listed as an essential service. Now, this is just a general idea of what force majeure is, but this is an important point that I would like to emphasize on. It's actually a point or a ratio that was decided in the UK case of Thames Valley Power and Total Gas and Power. But what it was stated in this case is that performance must be physically or legally impossible and not merely just more difficult or unprofitable. Now, this I think is very well put, in fact, because when they say that performance must be physically or legally impossible, this is ultimately what the force majeure clause intends to catch, where there is inability to perform a particular task and not just something that is more difficult or something that is more unprofitable at this point in time. If you fall under such categories, then perhaps force majeure is not something that you would be looking at. Now, this is the next question that we will deal with. What if the contract has a force majeure clause which does not specifically cover terms such as epidemic, pandemic, government intervention, quarantine, and diseases? What I mean is here, what if you have a force majeure clause which covers many other types of events, but not specifically this type of events, epidemics and pandemics, or government interventions and quarantines? Now, there are many standard forms of contracts that are commonly used in Malaysia, and one such example is the Public Works Department Standard Form of Contracts, Form 203A. Now, this standard form of contract includes the provision of a force majeure clause, but there is no specific mention of COVID-19 or even any such mention of words like epidemic or pandemic as an event described under the said clause. So in a situation like this, put very simply, the defaulting party would not be able to rely on the force majeure clause because the force majeure clause doesn't cover for such an event. It's as simple as that. A party in a circumstance like that would have to look at other provisions in the contract to see if anything else could be applicable to him in these circumstances. Now, a contractor in a PWD contract, for instance, would be able to rely on clause 43.1 Roman I of the contract in order to secure an extension of time to duly complete his performance under the contract, as opposed to making a claim under force majeure, which is likely to fail. I will explain this shortly, but what I want to explain here is that even though certain parties may be dealing with contracts like a PWD contract, where this particular event that has occurred in Malaysia, or the enforcement of the movement control order, which is a government intervention, is not covered under a force majeure clause, it doesn't mean it's the end of the road. There still is a possibility that you will have clauses in the agreement or in your contract which allows you to secure extensions of time. So while you're not able to succeed on a force majeure clause, you will be still able to achieve the same end result through other clauses in the contract. For example, a clause of, for extension of time under 43.1, the PWD contract, which states as follows here, clause 43.1, contractor's inability to secure such goods, materials, and or services that are essential to the proper carrying out of the works for reason beyond his control, unforeseeable at the date of closing of tender of this contract. So this is a ground, a very simple ground where a contractor will be able to get an extension of time. So although the JKR contract or the PWD contract doesn't state a pandemic or government intervention as one of the force majeure events, a contractor will still be able to actually get the same end result by relying on other clauses in the contract, such as 43.1. So it would, which I've already explained, the bottom part, yeah, the defaulting party would just have to prove that an event such as COVID-19 was unforeseeable that it was not reasonably contemplated at the time of making of the contract, and that the outbreak and the resulting impact on the defaulting party's ability to carry out its contractual obligations was beyond his control. And in such a case, of course, he will be able to get the extension. Under the next slide, which I've just changed to 2, I will deal with standard types of clauses that you would see in typical standard form contracts, specifically in the construction industry. There are, like I said, many other types of standard form contracts in different industries. In the housing industry, for example, under the Housing Development Act, we have the standard Schedule H and Schedule G types of sale and purchase agreements. But in the construction industry, we have these types of contracts. For example, the PAM contract, which is the Pertubuhan Architect Malaysia or the Malaysian Institute of Architects, have stated that a party would be able to seek for an extension of time if an event under clause 23.8a occurs, which is a force majeure event. And Article 7AD of the PAM contract has defined force majeure as any circumstances beyond the control of the contractor caused by terrorist acts, governmental or regulatory actions, epidemics, and natural disasters. So simply put, someone who is in a PAM contract will in all likeliness be able to say that the movement control order is indeed a governmental or regulatory action. The pandemic or the epidemic is indeed spelled out very expressly there as an epidemic, and therefore seeking for an extension of time under a PAM contract would not be difficult because the force majeure event in this case has in fact occurred. Let's take a look at another type of contract. This is a contract, a 1999 FIDIC contract, which is another very popular type of contract used in the construction industry. Clause 8.4 again allows for extension of time for completion, and under subparagraph D it says where you are circumstanced with unforeseeable shortages in the availability of personnel or goods caused by epidemic or governmental actions, then you would be able to obtain an extension of time for completion of the project. Clause 19 of the FIDIC contract actually has defined force majeure as an exceptional event or circumstance, A, which is beyond the party's control, B, which such party could not reasonably have provided against before entering into the contract, C, which having arisen, such party could not reasonably have avoided or overcome, and D, which is not substantially attributable to the other party. So if you see this, this is very similar to what I explained earlier as well, that the party is also required to mitigate such events and so on. But if you see the FIDIC contract, it actually spells all of this out, and it goes on to say this: force majeure may include, but is not limited to. These are very important words, but is not limited to exceptional events or circumstances of the kind listed below. And I say this because if you do not fall under any of these categories, category 1, 2, 3, 4, 5, as listed on the screen, it is still not the end of the road for you, because this is a non-exhaustive list which can be added, because the force majeure clause states that as long as you meet the requirements of A, B, C, and D here, then you would still be allowed to come under a force majeure clause. And like I said, 8.4D of the FIDIC contract allows for extension of time for shortages in availability of personnel or goods. So someone in a FIDIC contract would also, in all likeliness, be able to seek for extension of times, which means temporary suspensions of their obligations under the contract under particular provisions provided. The JKR 203A contract, which is the PWD contract, I have already spoken about earlier, so I won't deal with clause 43.1I. I have already discussed it earlier. But what I wanted to show all of you is that, remember I said clause 43.1I is something that the contractor has to rely on in a JKR contract, because the force majeure clause in the JKR contract doesn't cover for such events. So I will show that to you. This is clause 57.3. which is the force majeure event under a JKR contract. You would see paragraphs A, B, C, D, E, and F. The movement control order or the pandemic of COVID-19 unfortunately doesn't fall under any of these categories, A, B, C, D, E, or F. Perhaps it can be argued that it comes under things like commotion or disorder, but even then, I don't think it would fall under such categories. So a JKR contractor would have to be successful in an application under clause 43.1a, for instance, because force majeure is something that he will not be able to succeed on. So those are just the types of contracts that have force majeure clauses, and I've tried to explain briefly how it applies in different scenarios. Now, what if my contract does not have a force majeure clause at all? This is the next part of it. But if you're unable to fulfill your contractual obligations and you have no force majeure clause in your contract, put very simply, you could be sued for breach of contract. Now, under these circumstances, it may be prudent for a party similarly circumstanced to consider relying on the law of frustration of contract as provided under Section 57, subsection 2 of the Contracts Act. Yeah, so this is slightly more drastic of an action because you're not only seeking for temporary suspension, but you're actually seeking for termination, or you're looking at voiding the entire contract. So it is a lot more serious, and the requirements are also slightly more stringent. But in essence, Section 57, which is a statutorily defined, provides that a contract to do an act which after the contract is made becomes impossible, or by reason of some event which the promisor could not prevent unlawful, becomes void when the act becomes impossible or unlawful. So there are two key words here under Section 57. When it becomes impossible or unlawful, then someone is basically entitled to say that the contract has been frustrated. And normally, these events of frustration, or not normally rather, anytime an event of frustration occurs, there must be something that has changed the circumstances, meaning there must be a supervening event that has occurred, which has now caused the shift in obligations of parties in comparison to what such obligations were when the contract was signed. That may be a little convoluted, but I'll try and explain that a little shortly. Now, under this particular part, what amounts to frustration? Yeah. When the entire purpose of a contract has been taken away as a result of some supervening act, the contract is deemed to have been frustrated. Now, there are three primary elements that need to be shown in order to enable any party to rely on frustration of contract under Section 57. The first element is that the supervening act or the supervening event is one which was unexpected, meaning that the contract, when formed, had not contemplated such a supervening event. Secondly, that it is beyond the party's control. And thirdly, where such a supervening act makes performance impossible or radically different from that which the parties contemplated at the time of entering into the contract. So these are the three elements that you must meet in the event you want to be able to depend on Section 57.2 of the Contracts Act. As I've mentioned, the first thing is quite simple. It just has to be something that is that your contract could not have contemplated, because at that point there was circumstances were not that. What I really want to focus on here is the third element, which is that where such supervening act makes performance impossible or radically different. You see, the word radically different actually adds a lot of value to people who would like to rely on the doctrine of frustration, because if the circumstances of your contract has somewhat changed because of the supervening act or the supervening event that has occurred, then you can actually be successful in a claim for frustration of contract. The federal court in Malaysia, through the case of Ramli bin Zakaria and the government of Malaysia in 1982, basically said this: frustration occurs when the law recognizes that without default of either party, a contractual obligation has become incapable of being performed because the circumstances in which performance is called for would render it a thing radically different from that which was undertaken by the contract. So I think this has summed it up very nicely. It here means contractual obligation, and radically different here means when the federal court used these words, it means that if the contractual obligation is radically different than what was initially intended, then the contract can be considered frustrated as well. So it doesn't have to be a very strict interpretation of Section 57 where it must be impossible or unlawful, because the interpretation of impossible, at least, is interpreted very subjectively by our courts. It includes the test of radical difference of the parties' obligations as they were in comparison with the point when the contract was entered into. This is again a question perhaps that I think you all may be interested in, because force majeure and frustration, now that I've explained both of it, you might find that there are some similarities between the two, but the Singaporean Court of Appeal in Glahe International Expo and ACS Computer, I think, has summed it up again very nicely for us. And it states that the doctrine of frustration operates on a completely different level from a force majeure clause. Whereas a force majeure clause is an agreement as to how to resolve outstanding obligations upon the onset of a foreseeable event, the doctrine of frustration concerns the treatment of contractual obligations upon the onset of an unforeseeable event. So, as it has been put by the Singaporean Court of Appeal, it really is a difference of whether it has been specifically identified in your contract, meaning it's a foreseeable event, or it has not been specifically identified in your contract. If it has not been specifically identified, then there is no question or there is no issue of force majeure at all. The only option that you would have in the event you want to suspend, or if in the event you want to be free of obligations under the contract, is to actually try and void the entire contract by claiming under frustration under section 57 sub 2. Of course, like I said earlier, there are many contracts which you may not be able to claim for force majeure, but there may be other clauses in the contracts which would still be applicable to you in order to suspend obligations or to temporarily suspend obligations. Now, briefly, if the purpose of the contract has not been taken away entirely, then the party who wishes to rely on the doctrine of frustration will not be able to do so. So again, like I said, it's a very subjective interpretation when we say taken away entirely, because if I were to give an example, it would simply be an example of a situation where a particular driver has got a contract with you to drive you 1 kilometer every day, but suddenly, because there's been a massive road closure, the driver now has to drive 50 kilometers instead of 1 kilometer every day to pick you up. In such a situation, I think it's fair to argue that the contract has been changed or is radically different due to the supervening event, which is the closure of the road. And I think someone in such a situation would be able to claim that the contract has been frustrated due to the supervening event. Now, how do I invoke a force majeure clause? So this is a step-by-step guideline. There are only 3 very simple steps that I would recommend at this point. The first thing is look at your force majeure clause and dive right into it to see whether it includes events such as pandemics and epidemics. Now, if it doesn't include very specific express definitions such as that, then consider this. Does your force majeure clause include a catch-all phrase on things such as outside the reasonable control of the parties, or other things such as government intervention or regulation control, regulatory control? These are terms which are sometimes used in force majeure clauses, which perhaps could be applicable. Again, we would have to look at them individually. Now, if your force majeure clause has either events described in the first arrow or the second arrow, then you ask yourself this next question, which is whether COVID-19 has made performance actually impossible, or is it just less convenient and or more expensive? So this is the final step before you finally get your concluding remarks, that if the performance has actually become impossible, you will be able to rely on the force majeure clause. If the performance has merely become less convenient and or more expensive, you will not be able to rely on the force majeure clause. So I think it's a very simple guideline over here as to how force majeure applies. Ultimately, it really depends on how your contracts have worded it. So that would be where all of us should be looking at this point. This is the converse of what I just explained. What can I do if my counterparty claims frustration or force majeure? Which means, what if you are in a situation where someone is claiming force majeure against you to suspend obligations temporarily? I would say this is the step-by-step guideline that you should take. Firstly, check if the contract has a force majeure clause. That goes without saying. Second, check if the force majeure clause has events such as described, like the way it has over there, epidemic, pandemics, other things linked to that, such as government interventions and so on. Thirdly, check if there is any link between the force majeure clause or the frustrating event, whichever the case may be, as it may be, and look at the link between the event and the act of non-performance. How is it related to one another? And finally, once the above is considered, write to your counterparty and request for evidence of the factual circumstances that they are relying on. Something in writing always helps, because if matters get litigated later on, all of this would constitute as evidence in court. Now, a request should also be made seeking explanation as to why performance has now become physically or legally impossible. It would also be prudent to seek for evidence of steps taken by the counterparty to mitigate the situation. Could they have done something else? Was there, for example, methods which they could have deployed to avoid this situation? For example, if it's supply of goods, could those goods have been supplied through post or mail? That is steps that they could have taken to mitigate. So all of this should be considered when deciding whether or not parties should be allowed to rely on the force majeure clause. And finally, of course, the last two bullet points, if you're satisfied with the counterparty's response, consider entering into a written variation of the contract, meaning enter into a supplemental agreement, supplemental contract, whatever you want to call it, but rewrite or revisit the obligations of parties specifically during a period such as this, if, of course, you're satisfied with the reasonings that the other side gives. Of course, if you're not satisfied, then needless to say, you would have to consider escalating the matter to dispute resolution, which is through our Malaysian courts or through arbitrations or other mechanisms available. Now, in conclusion, I think what we can all take back from this session is that it is actually prudent for us to first check if your affected contracts have force majeure clauses. Now, if they do not, consider whether the MCO has taken away the purpose of your contract. If they do not, consider whether the MCO has taken away the purpose of your contract, which means whether you can rely on frustration. Now, of course, doing this will ultimately allow you to understand whether or not your contractual obligations are merely suspended. Is that what you're looking for? Or are you looking at a termination of an entire contract? Finally, although the above matters discussed primarily focus on the effects of the MCO on existing contracts, these principles on force majeure and frustration would actually continue to apply even after the 14th of April, if the COVID-19 situation still continues to exist and it still continues to affect people or parties' obligations under specific types of contracts. Before I just part my way and close this entire session of mine and hand it over to the host, to the MC, I just want to explain a little bit on the Housing Development Control and Licensing Act and how developers are now caught by the Schedule G and Schedule H standard sale and purchase agreements, where they would be required to hand over vacant possession to purchasers, failing which they would be liable to pay LAD. And in light of the recent decision of the federal court last year in BHL Construction and Ang Meng Lee, it has actually put developers in somewhat of a fix, because they are no longer able to get the extensions or modifications or waivers to their sale and purchase agreements from the controller of housing. That's what the BHL construction decision has said. So developers will still be required to actually deliver vacant possession within the time stipulated under the respective Schedule H or G agreements. And things like this could possibly cause a delay. So what we would like to see is perhaps steps being taken by the Ministry of Housing and Local Government in perhaps issuing out things like force majeure certificates. These are steps that we have seen being taken by the China Council for the Promotion of International Trade, whereby I think about 1,600 certificates have been issued to Chinese companies in February. The effectiveness of the force majeure certificates issued by the CCPIT, of course, is uncertain and untested as at this point. But the Hubei Provincial High Court recently advised its lower courts that COVID-19 and related government measures constitute force majeure. So we haven't seen this kind of steps being taken over here in Malaysia, but it would be a good inviting shift perhaps that we would like to see our government take, so that at least all parties and all players in the market are protected. Thank you very much.